Pooja, let me know.
Yes. Sumit, start.
Yeah, Sumit,
Yeah. Okay. Yeah. Good afternoon, everyone. It gives me great pleasure to extend a warm welcome to all of you to this exclusive masterclass titled Legally Compliant Reporting with a Gender Perspective by Ms. Abha Singh. We are truly delighted to have your presence today for what promises to be deeply insightful and enriching session. This masterclass is being held with the support of UNFPA. My name is Sumit Hararkar. I am the Assistant Director at Population First. This initiative is brought to you by Population First, a social impact organization committed to addressing issues of gender inequality and advancing social development. Amongst our flagship programs is largely a pioneering gender sensitization campaign that actively engages with the diverse stakeholders, including media, advertising, and academia, to promote gender sensitive content and challenges harmful gender norms. Through largely, we aim to foster inclusive spaces for dialogue and action around the gender and mental health, with special focus on the field of journalism and communication. Before we begin, I would like to share a few housekeeping announcements. Kindly switch on your cameras if possible. We would love to see you. Please ensure that your microphones remain muted throughout the session to avoid any disturbances. Should you have any questions during the masterclass, you are most welcome to post them in the chat box. This will be taken up during the dedicated question answer session toward the end. During the question answer round, if we wish to ask your questions directly, please use the raise hand feature. You may unmute yourself once invited to do so. With this, it is now my privilege to invite Mr. Yogesh Pawar, sir, the Program Director at Population First, to formally introduce our esteemed speaker for the day. Over to you, Mr. Yogesh Pawar, sir. Thank you.
Thank you, Sumit. Before I go on to talk about our esteemed masterclass conductor for today, let me tell everyone that our masterclasses are an extension of this mission that he spoke about, Sumit spoke about. Population First aims to not only deepen understanding of development and gender, but it also hopes to strengthen capacities for reporting through both a gender and human rights lens, intersectionally and beyond. Over the years, many renowned, respected voices like development journalist P. Sainath, eco-feminist Dr. Vandana Shiva, gender economist and women's studies expert Professor Vibhuti Patel, filmmaker Aruna Raje, and anthropologist and filmmaker Dr. Harjant Gill have led these sessions. Today, we are honored to add another remarkable name to this list. Advocate activist Abha Singh stands at the very intersection of law and social justice. She brings with her the insight of a lawyer, the discipline of a former civil servant, and the passion of a rights champion. As a practicing advocate at the Bombay High Court, she has built a formidable reputation for taking on cases that highlight gender justice, accountability, and constitutional freedoms while amplifying the voices of the marginalized. It is this rare blend of legal expertise and social conscience that makes her the perfect guide for our session. Ladies and gentlemen, please join me in welcoming advocate activist Abha Singh as she conducts today's masterclass on legally compliant reporting with a gender perspective. Abhaji, over to you.
Thank you so much, Yogesh. I have known for a very long time. I remember you as your work with NDTV. You've been very articulate, standing for the true cause. And I think that is why today I'm here. And firstly, I'm very grateful to Ladli, Population First, and UNFPA for having me for this masterclass. And I would like it to be very interactive. And I would be keen that I hope you can see me and hear me.
Yes, we can.
I hope so. If there are any questions, I would like to take them at the end of the master class. You can just take it down. And the topic is very interesting. So I'm going to start right away. This is a little brief of what all I have done, because I think that is very important, so that the interest starts once you know who your speaker is. I have from JNU, I've done my MPhil in child rights. I've been always interested in human rights. And when the topic I was choosing for my research, I said, no, it can be nothing but United Nations and the rights of child, study of child labor in India. So at a time when you had people going abroad and this, that, we were the ones who were going to these lock factories to see how children are working in these lock industry or in the carpet industry. And there also we saw the kind of issues they were facing. So that is me, master's in political science with an MPhil in child labor. And also I've done a leadership course at London School of Economics, a Chevening scholar. My work experience of 20 years at Government of India. I was a director of postal services. In fact, I was just thinking that I would have been chief postmaster general, but I quit because I always felt that the time has come that we need to raise the voice of the silenced. And that is what we are going to talk about. All these various laws, all the various crises faced by women and children, the violence, the gender-based violence which they have faced. So that is what I'm going to talk about. And I think that was primarily the reason that I left the government. In fact, today there are around 10 to 15 lakh children who are taking the civil services every year. And people who must be quitting would be barely 1 or 2%. So I'm proud to say that my husband and myself, we both, he was in the police and I was in the postal, we both left because we felt that there was a larger cause of the society, there was a larger cause for the marginalized community, and we should work for them. And that is why we are here. And I'm glad to be talking to you. And the topics which we have been taking off is that reporting with of compliance of laws, that responsible journalism, and it safeguards credibility. But I'm not going to only say that journalists or people who report it should be legally compliant. What is important is that compliance has to be even by the police of the laws. You know, gender sensitivity has to be maintained for which stakeholders? One is the police that is registering your complaint. Second are the NGOs that come forward to help you register those issues. Then the victim themselves. And then, of course, when finally the case goes for trial. And I would say not fourth, the fifth would be the media that ensures that these issues are brought to the forefront, and then the public supports them. We all remember the case of that young IPS officer who stood up, who went to check mining of sand mining, and you had the Deputy CM Ajit Pawar pulling her up. But kudos to that young IPS officer who stood up to her ground and said, you have to call up on my phone to know that who you are. So it is everyone who's a stakeholder has to see to it that we are compliant not only while performing, registering, but also while ensuring that justice is delivered. So that is what it is all about. And the topic which we have taken today, the importance of ethical, sensitive, and legally compliant reporting. I think ethical, we all have to be ethical. And sensitivity is something which is most important, because the laws which I was asked to talk about, POSH, that is sexual harassment of women at workplace, POXO, that is the prevention of crime against children, then domestic violence, and PCPNDT. So my talk today, my master class today will be around these four topics. That what are the main issues, how when you go to register the cases, what should be the level of sensitivity, how when it comes in the media, what should be the level of sensitivity, how it should be reported. And there are certain case laws which I'm going to talk about where courts have said, they have set down observations. So first, let's just see how internationally these things are, what are the international standards? Because while I was researching for the standards in India, I realized that sensitivity is something we all look up to. The UN, we look up to the UNICEF. So this is UNICEF which has uh, published certain records for the media professionals. And I'll be happy to know that the people who are attending the master class, what is the breakup? If it is, you can just WhatsApp me that there are journalists, there are students, there are what kind of people, so that I can curate it accordingly towards the end. So UNICEF has very clearly said that for the survivors, there are considerations that you have to be very clear that the survivor must understand that what information you're taking out, what information you're giving out in the space, his consent is there. If it is an adult, if it is a minor, then the family, the child, if it is a child, then his parents should be taken into consideration. You cannot just take out that crime has happened, something, violence has happened, and just to get a be first, just for TRP, or to get the more bites, or to get more people onto your story. You cannot just start putting it out in the space, because sensitivity has to be maintained from day one. And for that, it is very important that the privacy of the victim is protected, the consent is taken, and also you have to be very respectful and courteous, because the UNICEF says that you must have the principle do no harm. So there has to be no harm to the victim, no harm to the system. There should be no harm even to the case, because when the case comes for trial, at that time, if you have done irresponsible reporting, if you have be it in the social sphere, irresponsible reporting, or when you are registering the case with the police, when you are registering the case with the authorities, appropriate authority, PCPNDT says appropriate authority, POXO talks of the juvenile committee, the child welfare board. So at that time, when you're giving them the details, it has to be very sensitive. It has to be ethical, because you must communicate what the facts are, as sensitive, as gentle as you can, because you have to know there have been times when children have broken down. There have been times when witnesses and victims have turned hostile, because there has been an adverse publicity, there has been identity leakage, or because identity has been leaked, these victims have been threatened by the unforeseen people who will not come in the front but would send messages. So it is a must their identities are not leaked, their locations are not leaked. That is what UNICEF very clearly says in 3 things, that you must be respectful to the trauma, and you must respect the victim. You must see to it that they are not just given out in a manner which will be detrimental to the case and to the victim. And also the key points of reporting, which the international guidelines say, is that it should be survivor centered. But we should always have the survivor in the center, that his interest has to be guarded at any cost. Then there has to be accountability. That accountability should be not forgotten while reporting, and reporting can be with the authorities or reporting in the media, that the perpetrators, who the perpetrators are, that has to be brought out clear and crystal. But we have to avoid victim blaming. That is what the international guidelines are, and they say that victim blaming should never happen, because the moment you start blaming a victim, the victim is, as it is traumatized, the victim breaks down, has mental health issues, and in the long run would turn hostile, or would not even come to lodge a complaint. So this is something which is very important, which you need to look into. And you also have to have a positive and balanced representation. And what does that mean? That when you are reporting, you have to show that the victim's survivor strength. You have to give the survivor the confidence that, look, what has happened to you cannot be removed, But we will see to it that you get justice. We will see to it that the case goes to the logical conclusion. We will see to it that the perpetrator of crime is brought to book. We will see to it that even if he's a VIP, even if he's a political backing, we will see to it that the criminal is caught, put behind bars, justice is meted out, and the survivor is resettled, properly compensated. So this is what is important for everyone, whether you go to the police station to file a complaint or you're a media who is reporting the complaint. These facts must be looked into, and these are very important. And the most important thing is that privacy and confidentiality of the issue must be maintained. Because if you don't maintain privacy, if you leak the victim's name, the victim is going to be traumatized even more. You will have people trailing him, tracking him, family will be exposed. Tomorrow their safety will be compromised. And that is why the international guidelines, especially from UNICEF, it clearly says, do not share any story, image or video if it could put a child or their peers at risk. Even when identities are hidden, you may hide the face, but you will give everything away. वो इस गली में रहते हैं, वो वहां पे करते हैं, वो यहाँ पढ़ते हैं, उनके स्कूल का नाम ये है. And that means you have destroyed the case. Even before the case is built up, the case is gone. So this is very important. Also, one thing is very important is in this, that child-friendly language, gender-sensitive language is used. Because anything which is covered, which is reported, if even one word is out of place, if one word is out of place, it traumatizes the victim, it infuriates the family, it demoralizes the victim's family, and it emboldens the criminals. So just remember, the impact is like this. Your one wrong word of reporting, one wrong word, one wrong statement will destroy the case, the crime, the victim, the family. So that is why the language has to be very gender sensitive, and you must keep in mind also all the time your reporting, your thing should not be intimidating. That word we must remember. Sensitivity has to be maintained at any cost. It is not to be number one in reporting. It is not to get brownie points that if I'm an NGO, my name of NGO should come because we are doing such good work. If you are doing good work, it will be recognized in the long run. But do not just brand yourself so that you get some brownie points, you get your reels go viral. It is not about that. It is about sensitivity. It is about a crime which has happened. How sensitive you are, how quiet you are, how you manage to get justice without dramatizing. That is the word. It should not be dramatized. Crime is a crime. It should not be dramatized. So these are the things which we must keep in mind. These are the international guidelines. And now the first law which we will talk about, this used to be called POSH. I have not removed the nomenclature because we all knew it as POSH when the Me Too movement happened. At that time, it was called Prevention of Sexual Harassment at Workplace. But now it has been changed to, because a lot of people, even we felt that it is crime against working women at workplace and you are calling it POSH. What is POSH about it? So now the government of India has changed it to Sexual Harassment of Women at Workplace Act. So it is no longer called POSH Act, it is called SHWW. SHWW, Sexual Harassment of Women at Workplace Act. So this is the first, which is very important. When women have come out, they are working, and workplace is in the corporate, it is in the private, it is in the government. So it becomes very important that we know how is sexual offense at workplace defined and what is sexual harassment. Sometimes lot of cases, because little knowledge is a dangerous thing, sometimes people are registering cases though it may not be sexual harassment, it may be just affray, it may be just a verbal spat with somebody in your office or colleague, and women are misguided to say that go lodge a complaint under the SHWW Act, go lodge your complaint before the Internal Complaints Committee. But you should know that the Act says that if you file a false complaint, tomorrow action can be taken on you. So when it is not sexual harassment, if somebody has violently scolded you for coming late or is pulling you up 2-3 times, which you feel is not proper, then you have to see whether it has a sexual connotation or not. That is very important. And let me tell you, if you are misguided and you file a case under POSH, and if the Internal Complaints Committee reaches a conclusion that it was not a sexual harassment, you can lose your job. So be very careful. What is sexual harassment? It is a physical contact in advance. It is a demand or request for sexual favors. It is making sexually colored remarks. So you have to know what is a sexually colored remark. Sometimes casually one may say, oh, you're looking very smart. Let us not call it a sexually colored remark and go and lodge a complaint. Because now in today's permissive society, we are studying together, we are working together. Anybody can say, oh, you're wearing a very nice sari, you're looking very smart. So that will not be that will not constitute sexual harassment at workplace. So keep that in mind, that showing pornography, of course, is very obvious, but any other unwelcome physical, verbal, or non-verbal conduct of sexual nature. Your non-verbal conduct could be winking, making some lascivious gesture. So that sexual connotation is very important. I was handling a case where an elderly lady fought with a man in his 40s. They were neighbors and they were fighting over lift or things like that, putting plants. So one day that lady put a sexual harassment case on this young gentleman, and of course there was a police case on him, but when it worked out, it turned out that it was not a sexual harassment and it was a verbal spat, and they were fighting because they were neighbors and they had lift issues. Maybe he was keeping the lift for a longer period and she was waiting to go down. So please do not think that it constitutes a sexual harassment at workplace, because if you have a fight over lift, if you have a fight over water, who's going to fill the bucket first? These are not issues. These are, you have to see to it that it has a sexually colored remark. He's made some comment about your body part, if he's, things like that. So keep that in mind. That section 2N of the POSH Act is very important. What is sexual harassment is only 1, 2, 3, 4, 5. Beyond this is not sexual harassment. That you have to keep in mind. So your day-to-day fights in your office will not fall under this. And suppose somebody tells you to file and the ICC is set up and it investigates, you can lose your job. So what happened? Supreme Court initially in 1997 had set up the Vishakha guidelines, and I remember last year when we had the Ladli Award, I was present, and we had Bhanwari Devi. You all felicitated Bhanwari Devi. So it was Bhanwari Devi who was responsible for getting these Vishakha guidelines, and she tried to stop a child marriage, and she was raped by men of the village community, and then those men were let off because they said no, they are from the upper community, upper caste, they would not commit something like this. So at that time it was realized that what is a workplace is just not your office. If it is a woman like Bhanwari Devi, who in her context of work was trying to stop child marriage and was in the village, it was in the open, so that would also become a workplace. If you remember the Me Too movement, where women journalists said that they were called by a politician, a minister, and he was an editor earlier, to the hotel to meet them. So whether that hotel will become a workplace? The hotel will become a workplace if you have been called as a journalist, as a office employee, to report the work. So then it becomes a workplace. So be very clear. Workplace does not just means the four walls of your office, but it also means in context of your work, wherever you have been called, be it a hotel, be it a guest house. If you've gone to report your work to your boss, if he's in a restaurant, if he's in a hotel, then that will also constitute a workplace. So that is what is important. And it was after Vishaka guidelines, it very clearly said that it made it mandatory that you have to have redressal mechanisms, and also the Convention on the Elimination of All Forms of Discrimination Against Women, CEDAW. CEDAW is something which really has ensured that guidelines are there in place, and we have redressal mechanisms. And it was these people, if you see, from that 2013, Vishaka guidelines were 1997, but I'm traumatized, I'm sad to say that it took 20 years almost. 97 means 2007 and 13. So 16 years. It took almost 16 years to set up the act. And this also shows that there is an apathy towards women. Crime against women does not get the same sincerity which it should be given. But nonetheless, the progress is on, and let's be positive about it. And again, the POSH Act, the SHWW Act now, which I said, this was called POSH because you all know it as POSH. I have presented it as POSH, but as I have said, it is now called SHWW. It very clearly says that what it prohibits: do not leak information. Section 16 is very clear. It says details of the complaint, inquiry proceedings, identity and addresses of the aggrieved women, respondent or witnesses cannot be disclosed to the public, press or media. So please be careful. Section 16 is very clear. You cannot leak anything to the media, and information may be shared only to indicate that justice has been secured without revealing names, addresses, or any identifying particulars. So particularly for the journalists, for the people from the media, if you want to say that this case we have got victory, you can say, you can report the facts, but without revealing the name, address, or any particular fact which can lead to the identification of the victim. That is very clear. Section 16 is very clear. And if you go further, Section 17 says that there will be penalty, and the penalty will be as per your guidelines. It does not say that IPC, but it says in your office, if it is then it will be, you will service rules. Whatever your service rules are, if no service rules apply, then it will be the penalty from outside. So this is what, but I wanted to share this very important case of sexual harassment at workplace, which I subsequently handled, and now somebody else is handling. But when the matter came to the Bombay High Court, Justice Gautam Patel was there, and we realized that there were no guidelines. There were no guidelines in a case where somebody has faced sexual harassment at workplace, has lost her job, and comes to the court that her termination was wrong, her termination was wrong, and she should be reinstated. So at that time, Justice Gautam Patel, he set out the guidelines, which I thought I must share with you. And the bench, headed by Justice Gautam Patel, it very clearly said no names would be written. It would be anonymized as A, B, P, D, whatever. And we would, in body, parties would be only referred as plaintiff or defendant. No personally identifiable information, PII, such as email, phone number, address, or witness names would be included. So you cannot include any email, phone number, address while reporting or discussing the case. Orders, judgments on merits will not be uploaded. All orders, judgments delivered in private. So it will be in chamber or in camera. So this is a thing which was passed by Bombay High Court. And even the filing protocols, it very clearly said that personally identifiable information, it will be retained by the registry. Nobody would have it except the registry. Identity proof may be checked but not kept on record. So even if your Aadhaar is taken for proof of identity, the Bombay High Court order says that it will be returned. It will not be kept there so that anybody gets to know. And all, even affidavits will be using the short titles as A versus B or P versus D. And even in the CIS system, it will not be entered. So this is very important. You must know that Bombay High Court has come out with these guidelines, and now only advocate on record with valid wakalatnama can inspect or obtain copies. Records to be sealed and not released without court order. Nobody can just take it away like a lot of you people do, that go to the clerk and you get the order. In case of these cases of sexual harassment at workplace, these cases cannot be taken by you. It will only be there without court order. No third party digitization, even you cannot scan it, xerox it. Fresh filing will be sealed with main record. Witness depositions will not be uploaded. So I think this case is something which has for once crystallized that how it is going to be conducted in the court, because the bench, the judge was very clear that we are going to set protocols and see to it that these cases are not leaked, the victim identity is preserved. And hearings, for the hearings also, the court was very clear, said that all hearings will be in camera. There will be no online or hybrid. Even it was COVID time, but the court felt that there will be no hybrid and only physical, and only advocates and litigants were to be permitted. Support staff was also excluded. Minimum court presence, like it's written out in the order that court master and stenographer only. And what was the public access and media restriction? Orders in public domain only with specific court permission. So you could only report that much. That was with court permission. Only anonymized version will be released. Strict ban on publishing names, addresses, or PII. Media and all persons must ensure compliance or face contempt of court. This is what was very clear. The court, Bombay High Court, was very clear that if you are going to leak any name, it will be a contempt of court. And I would like to remind you that under contempt of court, there is imprisonment also. So you all be very aware that media disclosure was forbidden. Parties, advocates, and witnesses were barred from sharing any orders. Filings or judgments with media or on social media were not to be done without leave of the court. And witnesses were to sign confidentiality. And courts were very clear. Not once, twice it said the breach amounts to contempt of court. Also, for cases of sexual harassment, no recording or transcription of proceedings allowed. Any attempt to be treated as contempt of court. So if there was some hearing going on, and if stealthily also somebody is trying to record, it would be treated as contempt of court. So I think this case is the first case which clearly lays down how these cases are going to be conducted at the time of trial, at the time of hearing, because generally it is seen that a lot of victims' names, sensitive facts are leaked when they are in the court. But I can say, as a gender justice crusader, as a person who maintains utmost sensitivity towards crime against women, I think this order is something which is very relevant and which should be followed by one and all. So, in fact, because it was a termination case, and this termination will go to labor court also, the labor court and ICCs were also told that you will not, you will ensure that no identity is revealed. So, Labor Department, and also Labor Department was held responsible to ensure compliance and take action where ICCs were not found. So this is something which is very important, which happened in Bombay High Court. But at the same time, I would like to tell you about this order of Supreme Court, and which is on implementation. And this is by Justice Nagaratna, and Justice Nagaratna is going to be the next Chief Justice of India. And it has very clearly said, it says that the compliances should be done district-wise, and internal complaints committees should be set up everywhere. That is what the latest thing, and this is of 2025. So all of you who are working in the field, who get to know that there are no ICCs formed, then you must go and ensure, and you can quote this case and insist that internal complaints committee should be set up, because this is very important, because this order has the Supreme Court has took note of this. It has clearly said that there should be a National Women Helpline 181. There's the Cyber Crime Helpline 1930, and a toll-free National Legal Aid Helpline 15100. These could be of assistance to the aggrieved women to register her complaint or seek legal aid and advice under the provisions of the POSH Act. So once again, the National Women Helpline is 181, Cyber Crime Helpline is 1930, and the toll-free National Legal Aid Helpline is 15100. So when the Supreme Court is apprised of the matter, is pushing the thing, I think we as citizens of this country should be equally aware, equally sensitive, and see to it that the cases are reported in the right earnest, identities are not revealed, and justice is meted out to the victim, and the perpetrators of crime are put behind bars, and whatever punishment has to be given, they must receive. So there's another case which is very important, which I feel I must share with you. This is State of Maharashtra versus Rajendra Jawanmal Gandhi, 1997. And here the Supreme Court held. The Supreme Court said that a trial by press, electronic media, or public agitation is the very antithesis of rule of law. So you and I should know, end of the day, it is rule of law which should prevail, and we should not do anything which will cause hindrance to rule of law. And Supreme Court very clearly said that a media trial disturbs rule of law. It can well lead to miscarriage of justice. A judge has to guard himself against any such pressure, and he is to be guided strictly by rules of law. So I think this case is something which is very relevant. So in case if somebody is leaking information, not being discreet in such cases, you can always quote State of Maharashtra versus Rajendra Jawanmal Gandhi, 1997, where the Supreme Court has clearly held this, and also the order of Justice Gautam Patel, where it would be a contempt of court. So people who are not aware should also know that tomorrow, if you are violating these guidelines, you can face contempt of court. So I hope I have been clear on the POXO Act. Here I would like to, on POSH Act, I would like to tell you one more thing is the Internal Complaints Committee. We have also filed a PIL in Supreme Court, which is before Justice Suryakant, where we have said that internal complaints committees, the ICCs in the corporate sector, are toothless. The Act says that if a woman is facing sexual harassment at workplace, she can go to the ICC, lodge a complaint, but in real life it is seen that the Internal Complaints Committee in the corporate sector, they are so vulnerable, because if the ICC chairperson, who's a lady working in that organization, gets a complaint against one of her seniors, does she have the character, the courage, the gumption to take action against her boss? And if she does, I'm handling a matter where this woman was brave enough to take action against one of her seniors in the corporate, and she says that she lost her job because she was the ICC chairperson, and because of her report, one of the vertical heads lost his job. So we have gone to the Supreme Court stating that the ICC in the private sector, they need to be strengthened. If an employee has been made a member of ICC, then we must monitor that she is not terminated arbitrarily. If she is terminated for some reason, because when the matter came to Bombay High Court, the private sector said, oh, we are governed by the rule hire and fire. We just give a 3-month notice and we can remove anyone. So we said, if you follow this rule, how will the ICC work? So we have given suggestions to the Supreme Court that in case any private, if any private employee of the company who was ICC member or chairperson is terminated because was during the tenure as ICC member, then the report should be taken either by NCW, or the report should be sent to Women and Child Development Ministry, or it should be, we have made party the Ministry of Corporate Affairs. They should be there in the loop so that the ICCs actually work. Today in the corporate sector, the ICC are just in name. They are toothless because the ICC members themselves lose their jobs. Nobody is ready to see to it that the guidelines of the SHWW Act are upheld. So this is something which is now in the Supreme Court, and we are hoping that, I'm the lawyer and the petitioner is the person who lost her job, who was ICC chairperson in a private sector, and she says, I don't want my job back, but I definitely want that nobody faces the fate as I faced, that I lost a job because I was a very conscientious ICC chairperson. So this is something which I thought you should know. And now I will come to the POCSO Act, which is Protection of Children from Sexual Offences Act. And here also confidentiality is a must. And POCSO Act, we all know what the any child facing sexual assault, whether it is penetrative, non-penetrative, it is aggravated, these are there mentioned in the law. So if you want something more, I think we can work on it. But since my mandate was only to talk of compliance, but I would just like to do the little definition of this act, that this act came in 2012, and child pornography is something which it talks of, and it says even having child pornography with you is an offense. Making is a bigger offense, but even having data relating to child pornography is an offense which can lead to punishment for at least 7 to 10 years. So that is what also the way it defines penetrative sexual assault is in Section 3. So those who are working in this field may refer to the BEAR Act, and the definition is there in Section 3. And punishment is whoever commits sexual assault on a child below 16 years of age shall be punished with imprisonment for a term which will be not less than 20 years and which can also extend up to life. And imprisonment for life means imprisonment for the remainder of natural life. Earlier it used to be 20 years, means you've done 20 years, you will be let off. But no, now it means imprisonment for life is all your life you would be in jail. So now this is that is the new change that has come in. And also there is even stricter punishment for people committing crime on children, which when they are in position of authority. And authority means whether if it's a person is a police officer, if they are armed forces, security forces, or someone who's a public servant and commits assault on a child. So all these divisions are there. Wherever who takes advantage of a child who has a mental or physical disability. So all these things, or commits crime on a child who's less than even younger, less than 12 years. So all these things will come under aggravated sexual assault, and the punishment there is life imprisonment. So that was the serious offense, but there is something called also sexual harassment. So sexual harassment is defined in Section 11 of the Act, and it very clearly says, utters any word or makes any sound or makes any gesture or exhibits any object or part of the body with the intention that such word or sound shall be heard, or such gesture or object or part of body shall be seen by the child. So this is how the definition goes. Or makes a child exhibit his body or any part of his body so as to it be seen as being seen by such person or other person. So the definition is there in sexual harassment. Or also if you threaten to use in any form of media a real or fabricated depiction through electronic, film, digital, or any other mode, or any part of the body of the child, or the involvement of the child in the sexual act, or entices a child for pornographic purpose or gives gratification thereof. So this definition is very important. Right now, what we are facing is we are seeing that children, even young teenagers, 15, 16, are sharing their pictures, sharing their nude pictures, sharing parts of their body with their friends, which are then being misused. So let me tell you, if somebody has shared their picture, even if she's a friend, and if you are misusing it, it is an offense under Section 11 of the POCSO Act. And the minimum punishment for sexual harassment of this kind is 3 years plus fine. So please remember, even if your friend has shared some picture in good faith, do not share it, do not keep it, delete it immediately, because even if you've kept it, it is an offense under Section 11 of the POCSO Act, and it entails for 3 years imprisonment. So this is something which is very important, which you all should know. And now let us come to the compliance part. The POCSO Act very clearly says media guidelines are there on Section 23, and it says media cannot publish or comment on a child without complete and authentic information. Do not just go grab the eyeballs, just do not go reporting without having the facts. No report should harm a child's reputation or invade privacy. That is also very important, that you will not just run for it. And identity protection is very important. There is a strict ban on disclosing child's name, address, photograph, school, family, or any detail that may reveal identity. Also, disclosure only permitted by special court which is handling the matter if it serves the child's best interest. So any little information which you want, also only when the special court has certified that this bit of information can be taken, then only you can take it. And accountability, media owners and publishers are jointly liable for their employees' action. So POCSO, it is very clear in Section 23 that the publishers will be equally held accountable. So Section 23, I think you all must be aware of, and jot it down, because that is something which is very important. And it says, and this is Section 23, Part 3. The publisher or owner of the media or studio or photographic facility shall be jointly and severely liable for the acts of omission of his employees. Any person who contravenes the provisions of subsection 1 or subsection 2 shall be liable to be punished with imprisonment of either description for a period which shall be not less than 6 months, but which may extend to 1 year, with fine or with both. So please remember, you are not only getting into trouble yourself, but you will get your employer, your publisher also into trouble if you have leaked the information or you have been irresponsible in your reporting. So POCSO Act is very clear, and the penalties are 6 months to 1 year. In fact, I thought I will share this. I was arguing a matter in Supreme Court yesterday pertaining to POCSO, day before, and this was the case which we used, and the Supreme Court, and as late as 11th June 25, in the case of Sandeep versus the state of Maharashtra, directed that wherever the name of the victim is mentioned in the SLP, it should be masked. This is a reinforcement of the Section 23 of the POCSO Act. This prohibition on the disclosure of the victim's identity protects their dignity, privacy, and confidentiality. Also ensures that the courts, media, and all parties adopt anonymization practices in sensitive cases. So you can see the Supreme Court order in this specific case. It is directed that the name of the victim, wherever it is mentioned in the special leave petition paper book, shall be masked. So please know that. I have myself seen that people run to report these cases, they run to forward it on social media, but do not reveal the identity, do not reveal the name is something which is very important. Even in Nipun Saxena versus Union of India, this is again a landmark case on protection of victim identity. In this, it is very clearly, it talks about rape victims. It talks about judgment was divided into two parts, victims under the IPC and victims under the POCSO Act. So the court very clearly said that. And why this is a worry? Why should the court tell you? You and I should also know that what are the problems. The victims face stigma, ridicule, and harassment. And these are the reasons. Who wants to be stigmatized? Who wants to be ridiculed? Who wants that tomorrow your stand-up comedians come up and talk about your issues, which has happened? So that is the reason that you cannot leak the identity. And earlier it was 228A of the IPC, which is now 72 of the BNS, which clearly prohibits disclosure of victim identity and also allows exceptions under the strict conditions with competent authority approval. So even where you want to report the facts that the case is won, case is lost, or what is the facts of the case, you have to be very careful that the competent authority knows what you are reporting, and that is what is under 72 of the BNS and also 327 CRPC, which is now 366 of the BNS. It mandates in-camera proceedings with limited attendance. So do not try to juggle, ensure that you manage to enter the room, because so that you can be the first to report, you can be the first to get out with all the facts, and those who are present, it is their duty. The word used is duty of all present to maintain confidentiality. This is the word. So please ensure that you do not leak identities. And the state, this case has very clearly said, this is of 2018, that state and union territories should set up one-stop centers in every district to provide victim support. So as media personnel, as NGO activists, as responsible citizens, wherever these one-stop centers are not there, you can use of this case, Nipun Saxena versus Union of India, and ensure that all these compliances are done. So the Supreme Court clearly said that no facts enabling identification of a rape, sexual offense victim can be published except in the narrow exceptions allowed by the law. So you cannot give the name, photograph, address, relation, workplace, etc. This was again reiterated in this case, and also for the police. In fact, there was a case recently where the police, the IO only leaked the name. So those IOs, without taking name and without taking states, I want to tell them that the Supreme Court has very made it clear for the police that it should use a pseudonym to describe the victim, and FIRs in cases of rape or POCSO should not be placed in the public domain. So all these in IOs and police stations which are putting these out in the public domain, if any of them are listening to this masterclass, or you have friends with the police stations, please tell them you cannot put them in the public domain. Also, any memos or correspondence containing the name of the victim should not be given to the media or disclosed under the RTI Act. This is what Supreme Court has very clearly said, that even if somebody is trying to get it under the RTI, you cannot give it. And even if the next of the kin authorizes, the identity of the victim should not be revealed for campaigns without permission. We all saw the RG Car rape case where everybody was trying to get brownie points. It was party politics, one party trying to run down the other party, one opposition trying to run down the running the state, because you thought that rape can be politicized. So the Supreme Court has very said the victim should not be revealed for campaigns without permission of the competent authority, because the rights of the victim can be protected, because rights are without making her identity public. So once you've made it public, how do you protect her rights? So that is what is very clear. And I think for rape cases also, most important, for rape cases, we must have real strict guidelines, which has been set out in these last two cases. Supreme Court is coming down heavily on people that who are leaking identities. Even for the police, I think I'll go back again, which is very important. Police and disclosure rules are there very clear in Nipun Saxena, so it is important that they are followed to the T, they are followed. And rape, in the rape also, this was 376 earlier, rape cases, but now that is BNS of 64, which very clearly says that the rape punishment is now 10 years and life imprisonment. But according to this definition of rape, I have tried to cover here, because at times there is a very thin line, because sometimes what the latest issue is coming up is that people are filing false cases of rape. So it is all the more important that you know what the definition is, what constitutes rape, what does not constitute rape is again very important. And what is important is against her will, without her consent. So if there is a consensual sexual relationship, and there is a law which says that if you have a physical relationship under the false promise of marriage, so that is a consensual relationship, for the false promise of marriage would be treated as rape. So this is what you have to keep in mind, that till the time the law is there, you have to ensure that it is consensual relationship also, if it is without her consent, or if it is with her consent, without putting a fear of law, fear of death. So these are the things which the law says, and I think law should be followed to the hilt. So this is the definition which I have tried to highlight. And Section 228. Section 228 of the IPC very clearly, it says that publishing or printing of information that may reveal the identity of the victim of offense under these sections is punishable up to 2 years imprisonment and fine. So this is very important. The sections which are like your BNS sections I will take up. It was 376 is now section 64, then section 65, 66, 67, 68, and 69, 70, 71. So all these sections, if there is an offense under that, and if you're revealing the identity, you can face fine up to 2 years. So I think even when you are reporting, please see to it that identities are not revealed also. But if it is in good faith, with written exceptions are there by written order of the investigating officer in good faith, although we just did a Supreme Court thing which said no, even the IO should not give it like this. And if the victim is dead, so there is a clause that if the victim is dead, then minor or mentally ill, with written consent of her kin, but only to a recognized government approved welfare institution or organization. So there are so many clauses. I think it is sensible not to reveal the identity at all, to be very sensitive, hypersensitive, because when these cases come for trial, because you have leaked so much information, the cases get spoiled. Arushi murder case, till now, nobody could reach the real truth. You have a movie on that. The CBI also had to close the case because the forensics had been destroyed. The state police, the case was transferred from state police to the CBI because the place of crime was messed up. The doctors were approached. So these are the things which need to be kept in mind when crime against women is being handled or crime against children are being handled. And as I said, that Kolkata rape case, the identity of the victim, name, occupation, photographs, everything was spread out. Is this compliance? No, it is not, my friends. It shows how much we can fall, how much desensitized, dehumanized we are, that we are trying to leverage such a brutal rape, that we are trying to get brownie points. If we are politicians, we are trying to run down a government by trying to come out with even gory details. Is this what we are there for? No. Crime is a crime which should be handled with utmost sensitivity, utmost responsibility, and seen like fact was that whatever facts were there in the domain, you could see that she was the RG car rape case, there was a single rapist. But people tried to put in insert stories saying that it was a gang rape. And from day one, I said, no, that's not a gang rape. It's a one person who, an alcoholic who had the permission to be in the hospital. He was a public police link. And then CBI also later on said the same thing. So let us not put a wrong narrative. Let us not try to destroy a case by saying that it is a gang rape. So tomorrow, when the defense comes, they will also use these stories which you have put out. Sushant Singh Rajput is a case where it was a suicide, but people, for their vested interests, because Bihar elections were around the corner, the family was getting all the push that you said that it is murder when it was a suicide. So many channels became famous. I'm sad that there were these reputed anchors who used Sushant Singh Rajput to increase their TRP. And I'm not taking names, but we all know who these anchors were, who these politicians were. So that is not sensitivity. That is not reliable reporting. That is not ethical. Where is the ethics? And when you have a duty as a citizen of this country to be ethical, when the constitution says that you have certain duties towards the country, then you are violating the constitution also. So another thing which is very important, which I felt you all should know, is that when a woman reports that an offense has been committed against her under all these sections like 64, 65, 67, 68, 70, 73, 74, 75, 76, 77, 78, and 122, if these women are reporting, then it is mandatory. It is mandatory as per law that the information be recorded only by a woman police officer or any women officer. So if it is a case of rape and I wanted to file a complaint, I don't want to go to the police station, then there is a provision in the law that the police should come to a place where the victim is comfortable. It can be her home, it can be some NGO, it can be some NGO person escorting her. So these are the things which have to be kept in mind, that when you are reporting, it has to be a woman officer, and also the victim should be most comfortable. If it is a child, then all the more reason that the child should not be brought to the police station. In fact, when we go to the juvenile courts, when we go to the shelter homes, we as lawyers are also supposed to not wear our bands, not wear our black coats. Police is supposed to go in civil, because the law, the juvenile law is very clear. It says that the children should be most comfortable. They should not be scared. They should not be inconvenienced by the uniform, be it of the police or the lawyer. So that is what the law says, and that is where you have to ensure that these things are complied with. So we have covered these two. If there are any questions, you can jot it down and we can take it up later. And now we come to DV Act. And I think this is something which is in my 10 years or 12 years, I would say, in my 12 years as a practicing lawyer and as an activist, I would say domestic violence happens. Figures say that 1 in 3 women faces domestic violence, but I would say 1 in 2. 50% of the women would have faced domestic violence at some stage of their life, at some phase. So every second woman, I would say, every second woman who is listening to this case or is here or we meet would have faced domestic violence at some stage of a life. And domestic violence is just not beating. It is also economic cruelty. It is emotional cruelty. So economic can be when your husband denies you the basic expenses to run the house, when your husband denies you the basic expenses to buy your provisions for the house. He does not pay the fees of the children on time. So so I think that is what, and it is important that we talk about it. In fact, I remember during COVID times, I would get so many calls because people were in the homes, domestic violence had increased. People could not reach out to the police, they could not reach out to the shelter homes. So domestic violence was really at its peak during COVID. And So I thought domestic violence is something. When I was told that we must discuss domestic violence, I said for sure. And the definition of domestic violence is section 3, and which I think we all should know. We all should know when we are victims of domestic abuse. So it very clearly says act, omission or commission, or conduct. So you see, it is not that somebody is just beating you. Domestic violence can happen without even active movement of hitting. It can be omission, like you just forget to pay your wife the expenditure for the house. You forget, you overlook, you don't bother, that you don't let her eat. I was handling a matter where a pregnant woman said that my mother-in-law would not let me eat with everyone on the dining table. I would have to sit in the kitchen on the floor and eat. That is domestic violence. She said I had to go to the Gurudwara to eat my food. That is domestic violence. So any act, omission, or commission or conduct of the respondent shall constitute domestic violence if it harms or injures or endangers the health, safety, life, limb, or well being, whether mental or physical. So the law is very clear. Even mental torture is domestic violence of the aggrieved person or tends to do so, and it includes causing physical abuse, sexual abuse, verbal and emotional abuse, and economic abuse. So just see how progressive the laws of India are. That we are ready, the country, the government, the law is there to take care of your emotional quotient also. That if somebody is troubling you emotionally, if somebody is troubling you economically, forget physical, even emotional abuse will be treated as seriously. And this law is a civil law, it is not criminal. So remember that to avail relief under domestic violence, you will go to the court. You will not go to the police station. You will go to the magistrate court. You will go to the protection officer of your area, and you will write out the violent abuse which you have been facing within the four walls of your house. So, as I said, that if anybody harasses you, harms you, injures or endangers you with a view to meet any unlawful demand of any dowry, any property, any valuable security, then that is also domestic violence. Also, if somebody is threatening you for anything, that even a threat will constitute domestic violence. And of course, injures or causes harm, whether of physical or mental, to the aggrieved person. So the aggrieved person will definitely be the woman in this case, because domestic violence is primarily for the women of the house. It can be, and the women is not only the wife. Domestic violence is applicable in live-in relationships also. A woman who is not married but who is living with you in a relationship which is similar to marriage will get protection under the DV Act. So domestic violence is something which most prevalent, and we are trying to, in fact, the relief that you can get in domestic violence is okay. We'll first do the relief. You can get domestic relief under the you can ask for residence. If you are facing domestic violence, you can ask for you can request the court that the husband be in the own same house. The area is divided so that the portion which is given to you, your husband does not enter that area. If you feel he is bullying you at your workplace, then the magistrate has the power to issue a restraining order that the husband within 500 meters of your office will not be seen. If your children are there and he is troubling them, then within 500 meters of the school, he will not be seen. So DV is a very powerful act. It ensures that you get a restraining order, your workplace is safe, at home you have a safety. If you can, CCTV cameras can be installed in the public area, in the public space. Also, if your husband is not providing you maintenance, as I said, if it's economic cruelty, if he's not responsible, he's not providing for the fees of the children, he's not providing for the food of the house, not providing for shelter, clothes. So the magistrate, after you have proved to the magistrate, you have convinced the magistrate that you are a victim of domestic violence, you are facing economic violence, you are facing emotional abuse, the court can order a fixed amount of maintenance, which is called interim maintenance, till the time further action takes place. The further action can be filing of divorce or filing of a police case. But if you are living in that house and your basic needs are not catered to, then this DV Act comes to your use. It's most handy. It will provide you shelter, it will provide you food, it will provide fees for the children. So under this, the magistrate is most powerful. It can provide, in fact, we recently got a very good order from the family court, from Bandra court. In fact, the court has given an interim till the time the case goes on of divorce, an interim of 2.5 lakhs per month. So it also says that compensation or interim maintenance will be given suiting to the lifestyle of the wife. So if you are entitled, if the husband has a car, you should also have a car. If the husband is flying first class, why not you should fly, at least not first class, but at least by flight you should be going, house help. So all these things, I think DV is a very powerful law which you all should know. And domestic violence is something which has come to the protection of women, and the magistrates have given very favorable orders, and does not take much time. The jurisdiction will be the closest magistrate court of your area. Like I can say that people living in Worli go to Bhoibara court, people in Churchgate and all go to here at Channi Road. So all the local courts, you will get to know the jurisdiction. It is in your respective jurisdiction. You have to file in the magistrate court, and the magistrate court then refers the matter to the protection officer, and then the protection officer, in every area there are protection officers. I was telling you during COVID, when women would call me, I would try to take out. So Mumbai, every area has a protection officer. You all should see to it that you all have the number and the name of your protection officer, so that in times of need you can call them. So under DV, when we file a DV case, the magistrate refers to the protection officer of that area. He will visit you and make his own independent analysis, and then the protection officer will serve the copy to the other side and also make a report if the magistrate wants, and then the hearing takes place. So that is what is of the DV, which is very relevant. And dowry, of course, Nikki Bhatti's case, we all have been following. And recently we saw how brutally Nikki was burnt in front of her 8-year-old son. And the family said that they were asking for more money. And because Nikki's parents were not giving that kind of money, she was burnt alive. Also, Nikki and her sister were making reels, and the family was traditional. The family did not want to make reels. So how can such brutality happen in today's civilized world is my question. And that little boy, how traumatized he must be to see his mother burning. So it is necessary that this case is taken to its logical conclusion. You would be appalled, you would be shocked to know that as per the latest NCRB figures, every year 6,400 brides, 6,400 young married women are burnt alive. They are murdered for dowry. They are murdered for car, they are murdered for gold, they are murdered for a house. How shocking, how mentally depraved these husbands and mother-in-laws and father-in-laws are, who are killing their brides for greed of gold and house. But this is the reality. So all those who come and say that women are misusing laws, or those who have made an organization called Men Against Violence, I want to tell them, give me 2 cases of reported that men have been burnt by their wives or the in-laws for beating them up or not giving them money in the house. So dowry death, in fact, in the dowry death cases, the cause of death in the FIR is written kitchen fire. So in your own house, in your own kitchen, in your bedroom, if you are killed, it is the bride, it is the housewife. And that is why I think we have these 498A was earlier law, and now it is called section 80 of the IPC and section 80 of the BNS, and which clearly says that if a woman dies within 7 months, of her marriage, 7 years, sorry, 7 years, if a woman dies within 7 years of her marriage, and if it is related to dowry, so if the immediate incident before her death, there are reasons she has called up her home that my in-laws are troubling me for dowry. If she has written to her friend that I am being beaten for dowry, it will be treated as a dowry related cruelty harassment. Punishment is minimum 7 years to life imprisonment. So here I would like to tell you what is very important is, because there was a recent case where the Nagpur bench of Bombay High Court, it absolved the husband and his parents of 498A case. They were in jail. The court said a case of dowry death is not made out, and the reasons it said was that when the woman died, the police station was nearby. Nobody from the girl's family went to register an FIR. So it is very necessary that if a death like that has happened, even if it is an accidental death, you must go and register an FIR. So that is what the court reached the conclusion, saying that it was a suicide, and that suicide was not motivated, instigated by the in-laws. In fact, I was doing a TV show, and I remember when the media asked me, because they said, oh, the court said that filling water at 12 in the night is not cruelty, or not getting a bed to sleep on, sleeping on a carpet in the house is not cruelty. So then I read the detailed order of the court, and what it said was that it is necessary that when you are reporting, you must know the other side. Why the woman filled water at 12 in the night? Because it was told that in that village, the BMC water in that place, it would be the Nagpur Municipal Commissioner, Nagpur Municipal Commissioner. So that the local civil supplies, the water came only in the night. So it was not only the bride that was filling water at night, it was the mother-in-law, sister-in-law, and in every house people were filling water in the night. So that was one charge which got dropped. Then the second charge was that they did not give her a bed to sleep on. So then it was what was said that when guests came to the house, the bedroom was given to them, and here the mother-in-law, the bride, and everybody slept in the drawing room on the carpet. So please, when you are making charges, see to it that those charges stick. They are not flimsy, they are not on hearsay. Also, what the court said, that even she had come to her mother's house before she died, very clear proximity, say 10 days or 15 days before, but she did not mention the cruelty or harassment. So my advice to all of you is that if you are facing dowry related harassment, if you are being troubled, please, in today's time, WhatsApp your friend, put an email, because now these WhatsApp and emails are credible evidence in the court of law. So when the trial happens, whatever your emails are, whatever your WhatsApp chats are, they would become credible evidence, and the courts would look into it. So it is necessary that that case got discharged, and that is why today in rape cases, the conviction rate is barely 28%, which means that out of 100 cases, only 28 people get punished and the remaining 72 go scot-free, because these type of facts weaken the case. You do not file a FIR, you do not have evidences. So please, if your husband is beating you, if you are facing domestic violence, maintain a record. Go file an NC in the police station that today I was beaten up. Or if you have a broken bone, go to the hospital and take a medical and keep it. Even if you're trying to protect your marriage, have these records so that at a time when you really need to save yourself, these evidences will become uh, your protector, your protection. So that is what is very important, because if Nikki was being beaten for the last 6-7 years, what stopped her from going back to her house? Now her father and brother, they all are coming forward and saying फांसी दो. But मैं पूछना चाहती हूँ उनके माँ बाप से कि जब ये बच्चों की पिटाई हो रही थी, आप क्यों नहीं घर ले गए? You don't want to take your daughter when she's being beaten up. But when your daughter is dead, then you want justice. Why should such a situation even come? That is what is important. So if any woman is facing dowry related abuse, is facing domestic violence, please speak up, maintain a record, go to an NGO. If your parents are not taking you, go to some NGO that will help you find a shelter. That is what is important. And here is the crux which I say, that is why it is important that every girl child every married woman should take share of her shelter from her parents' house, because the Supreme Court law is very clear. Girls, women have a right to their ancestral property. They have a right to their parental property. And once you are economically empowered, such type of situation will not arise so easily. It may arise, but the other side, your husband, your partner will know that she has her own house, she has her own income, she is not dependent on me, she can just pick up her bags and go. So see to it that you are economically empowered. What is due to you, take your share. This is another case where wrong reporting. This MP Lohia and others versus State of Bengal, the Supreme Court, this was a dowry case, and here the journalist, Doomed by Dowry, written by Kakuli Poddar, based on her interview of the family of the deceased. The court said, giving version of the tragedy and extensively quoting the father of the deceased as to his version of the case. The facts narrated therein are all materials that may be used in the forthcoming trial in this case. And we have no hesitation that this type of articles appearing in the media would certainly interfere with the administration of justice. So please don't put up all these facts. You all are well read, aware that these important facts, which would become evidences at the time of trial, don't put words into the mouth of the family. Even if the family wants to tell, be sensible, be mature, do not file them. And then what the Supreme Court said, we deprecate this practice and caution the publisher, editor, and the journalist who was responsible for the said article against indulging in such trial by media when the issue is sub judice. However, to prevent any further issue being raised in this regard, we treat this matter as closed and hope that the other concerned in journalism would take note of this displeasure expressed by us for interfering with the administration of justice. So here you see in MP Lohia and others versus State of Bengal, Supreme Court expressed displeasure. And it actually cautioned the publisher, editor, and the journalist that you are playing with justice. You are destroying the administration of justice. Because of you putting out all these facts, the case was weakened. The other party now knows, and it can always traumatize the father. It can always get a alibi to say to it that we were not there because you have already shown everything to them. So it is very important that we should not divulge these sensitive issues. And the Supreme Court very clearly, if you see, I think you can write it down, note it down, that this is very important. And for administration of justice, reliable reporting, sensitive reporting, ethical reporting is very important. MP Lohia and others versus State of Bengal laid a landmark thing. And So this is what is in dowry related issues, in domestic violence related issues, and now something which your people from Ladli were very keen, that I, especially Sharda ji, who called me up and said, Abha ji, you must speak on live-in relationship. I said, fine, because in today's time, with so many marriages ending up in divorce, a lot of people do not want to enter marriage. They want to be in a live-in relationship. And the definition of live-in relationship is given in Section 2A of the DV Act. And also in the case of Veluswamy versus Patichamamal, this is of 2011 Supreme Court. And these are the 5 ingredients for a live-in relationship. Because if you are in a live-in relationship and you want that you get all the benefits, you should get interim maintenance, your children should inherit the property. So this is what it is. And now, because now Uttarakhand has come forward and said we are going to register live-in relationships, there is a issue which the country is facing, that whether live-in relationship should be registered or it violates a right to privacy. That is something which you and I need to talk about, you and I need to discuss. But my issue is, my logic is, when DV Act recognizes live-in relationship, when children born out of live-in relationships can inherit property, then who is a state to invade into my privacy and ask me to come and register in a police station? Because then the moral policing starts. So this is something which needs to look into. But these are the 5 things that they must have lived together as a husband and wife in front of the society. They must be of a valid legal age. They should qualify. None of them should have been married. Also, they must have voluntarily cohabited for a significant period of time, and they must have lived in a shared household. Now, this is something which now that it is here, shared household is very important. Shared household is something which for any married woman is very important, because even if your marriage is breaking down and your in-laws and your husband want to push you out of your matrimonial home, do not leave the house. Because tomorrow when you file a DV, you will get a restraining order, you will continue to stay in your house, because the legal definition calls it a shared household. And a shared household is the household where, as a young bride, you have come and you have lived there for a couple of years. So you may not have a legal ownership of that house. The house may not belong to you, it may not belong to your husband, but it may belong to your in-laws. But right to residence, nobody can take from you. If you're a legally married wife, or even if you've been in a relationship for a long time in that shared household, you have a right of residence, and that is how the law protects you. And so let us not look down upon live-in relationships in today's times. I would say, with divorces turning ugly, so much of custody battles happening, live-in relationship is the solution to the empowered women, the woman who's working, who wants that she should not be made to only do the unpaid work of the house, who wants that in a relationship the partner, the husband, whoever he is, should equally work in the house, should equally look after the children. I think for a woman today, equality, and when Article 14 talks of equality before law and equal protection of laws, I think live-in relationship is the example. Till the time India does not get a prenup, because we don't have a prenup, divorces are getting ugly, they are being stretched, children are suffering. So I think today, when I talk to you, and you all are so well read, you all are actively involved, and you all can make a difference. I think in today's masterclass, we must talk of prenup, and we must write a letter to the Ministry of Law that the time has come to have a prenup in India, so that before marriage, an agreement can be written. Because some people are trying to write, but let me tell you, it is not enforceable in the court of law. So to avoid all the unpleasantness of divorce, all the unpleasantness of custody battles, we must have prenup as it is in the West, so that both the persons, before entering into marriage, have a written agreement, so that if there is a breakdown of marriage, it can be done peacefully without any ugliness. So this also, DV cases, if you want, it can be in camera. Of course, majority of the DV cases are not in camera, but there is a provision. They can, if you make a special demand, it can be held in camera. That means if it is in camera, then media will not get the details to write about it. And Section 16 of the DV Act, it clearly says that they can be held in camera. And if the magistrate considers that the circumstances of the case warrant, and if either party to the proceedings also desires, then they may be held in camera. And so you have the there also that they will be held in private without any public or press present, and they would protect sensitive information and ensure fairness in cases involving minors, sexual offences, national security, or personal privacy. So all this is done basically to protect the individual's dignity, so that your right to life, Article 21, Supreme Court has said, right to life also means right to live with dignity. And dignity is compromised if my personal things are made public, if my personal things are written about in the social media, in the press. And that is why in-camera provision is also made for DV cases. So this is last. Now I come to the end. I think this was the last topic which I was asked to cover for you. And PCPNDT was an act which came in 1994. And I think it was 90s was the time when maximum female feticide was done, 90s and 2000, that people, we all know that India, not only India, world over, there is a craze for male child. Very few people would be there who I keep seeing lovely posts of Yogesh Pawar for his daughter who is the shining star of his house. So I feel every daughter is a shining star, but they are not so progressive as we are here. But in the north or in the rural areas, there is a craze to have only boys. And so Amartya Sen was compelled to say that the millions that we have lost, millions of girls, where are they? So there was a stage, and that is why the government was compelled to bring in the PCPNDT Act, which said that you will not do sex selection. And I'm saying that sex selection may have stopped in India, but these people are now going to Bangkok, they are going to Dubai, they are going to different places. And I would like to say why that you would see me posting the maximum pictures of my daughter Isha, who's in herself was a lawyer and who's now in the police. So you and I, who are progressive, do not think there is a difference between a girl and a boy, between a son and a daughter. But there is still a society which still hankers for the girl child, for the boy. So I have seen so many places where I ask them, why a third kid? They'll say, no, the first two were daughters. You will also see that there is a third child who's a son, because after two daughters, people have gone for a sex selection. And that is why this PCPNDT Act was got in, and where the government made it very clear that every diagnostic lab, every ultrasound clinic would be registered, and only they would be doing tests. Sonography will be done only for genetic disorders, and section 22 specifically prohibited sex selection. And then the section 23 of the act talks of 3 years imprisonment. And so we had this act, and let me tell you, I think thanks to this PCPNDT Act, female feticide has gone down. We can see that the girl sex ratio has increased. In fact, states like Kerala have more girls than boys. So this clearly shows where education has come. The girl preference has increased, and people are happy with their daughters, because we had those traditional rituals where you said it will be the son only who will give Agni and all that, and Karta could be a son. Now it is a daughter who can execute your will. It can be the daughter who can inherit your property. It is the daughter who can perform your last rites. So there has been a mental change also. But the PCPNDT Act, if we see, it clearly said that there can be no advertisements. And the Supreme Court also in 2017 introduced the doctrine of auto block, that said that all these search engines, because people try to find out which doctor they can go to get the sex selection, where they want a son. And basically in states of UP, Bihar, Punjab, Haryana, these are the states where sex selection has been too much. So these sites were blocked, and also Supreme Court has ordered that it said that a nodal agency, there should be a nodal agency so that these websites are blocked, and also under the IT Act also measures are being taken. And so what is important is that because social media is there and people are still doing sex selection, so it is not easy. It is even 40 search engines are nothing. So, but still an effort is being made. Things have come down. And PCPND, although I would like to tell you, when I was working on this, researching on this, that this act, it came in 1993, 94. So, 1994 it came. So there was a 20-year study which said in 20 years, only 1,000 cases were registered under the PCPNDT Act, Section 23. And when we all know lakhs of women were forced to abort their fetuses because it was a girl child. And that made me thinking that why is it like this, that a woman who is going to be a first-time mother or a second-time mother is forced to abort her girl child, but does not have the courage to come to the police station to register her complaint. So in a span of 20 years of this law has also not been very effective, because if only 1,000 complaints were registered and conviction was only 100 cases. So that shows that the mother who was forced to abort her child did not come forward to pursue the case. Only in those cases where the marriage is broken or they have moved out, they had the courage to come forward. Because when you ask these women, they say, look, we have lost a child, but if we go and lodge a complaint, we would, our marriage would also break, because ultimately if my mother-in-law is forcing me or my husband is forcing me, it is with the consent of the family. So PCPNDT, Supreme Court may have given out orders that made an offense, like 23 is Section 23, it talks of offense, but still female feticide is still happening. I remember the news reporting done by one of the journalists of Bede, where around in one sack, 877 or some fetuses were found in this district of Bede, which has the highest female feticide in Maharashtra. In India, Bede has the highest female feticide, and so it is still happening. I think that is where we need to do reporting. But when you do the reporting, it has to highlight the clinic and the hospital. So we don't do that. We try to bring the story of the woman and the family who are poor, who have social compulsions, but the big fish go scot-free. So I think at least in PCPNDT cases, we need to do public shaming. We need to make people aware. We need to tell the families that the daughter is equally capable. Educate her. She will take care of you. You educate her, empower her. She is as good as a son. I would say that a daughter is more than a son. My father always used to say this when we were growing up. A son, and I think all of us know this, a son is a son till he has a wife. A son is a son till he has a wife. A daughter is a daughter all her life. So I'm not saying that, but a daughter is equally capable, competent. So this PCPNDT Act has not been very successful, but you and I being aware, we being role models, we coming out with these issues, making the public sensitized that be it 2 daughters, be it 2 sons, whatever you think of the country's population, do we have the resources to have so many children? That is important. And this meta preference for a boy. So wherever there's the 3rd child and it's a son, you will know that the 2nd child, who was a daughter, was always sidelined. I have met so many girls who are number 2 in the house, and they say we were always sidelined because the elder child, being a daughter, was got all the love, and the third child being the son. So the girl, the middle child, who is a girl, grows up with so many insecurities. So I think if Ladli should also look into this matter. Population First should also look into this matter. The wherever there is a second child, girl child, and then there is a son, how are we handling their mental health? How we are looking into it? These things I think we need to look into. And I think I have covered all the issues, and I would like to say that reporting, the laws are very clear, but end of the day, what is important is our own conviction, our own ethics, our own values. And if we feel for the other person, if, as court said, justice should be something which should be a governing principle. If we are governed by justice, if we respect the rule of law, if we feel for our brother human beings, then only we will be sensitive, we will be compliant, and the laws are there. And if we are not going to see that the other person is not doing it, but you have to be truthful, you have to stand by your values, you have to do ethical reporting, you have to do ethical journalism. If you are in any position, if I'm a lawyer, I have to be an ethical lawyer, and I have to see to it that I defend my client with the facts of the case. I do not bribe the registry, I do not bribe the judge, I do not bribe the police officer to weaken the charges, I do not bribe the investigating officer to file a false charge sheet, or people who bribe to put charges. Because what happens is that the charge sheet is, if we are in Maharashtra and I don't know Marathi, and my FIR is in Marathi and I sign on it, I don't know what is written. So here I want to tell you the last thing, that the law provides for that whatever language you know, your FIR should be written in that language. So if he is writing in Marathi and you are Assamese, or if you're from UP and you don't know Marathi, please say, give me a translation, and the police station is duty bound to give you a translated FIR. I think if we become that aware and that only we start doing it, lot of cases where the charges are not put properly, or where charges are weakened so that the conviction does not take place at the time of trial, that would be avoided. I think this is all that I had to say today. And thank you so much. Thank you so much. And I think we can come to the last page that was there. We can just put it, what was the topic?
Pooja, if you can come in. Yeah.
Yeah.
Yeah, we had a couple of questions, so which is why.
Yeah, so we can.
So I wanted to start off straight away by asking a question that I myself had, Abhaji. This is Yogesh. I wanted to ask you, there is a climate being created where people are saying that men are being affected by these laws, which supposedly are made to protect women, whether it is the 498A, or whether it is domestic violence, or whether it is other cases, other laws. So you notice that increasingly many of these groups are coming together, and now they are not only lobbying with the government, which is beginning to make sympathetic sounds, but sections in the judiciary are also being screened, films are being screened for them, and where men are being shown as martyrs and stuff like that. So this is being highlighted, and a sort of a climate is being created. Whereas, like you pointed out just now, the numbers show, NCRB numbers show that actually the number of women who die, number of women who face this harassment is so much more larger. So what is the way out? How do we counter this new challenge which is coming up, and will it take away all the progress that we have made with women's laws?
Yogesh, what you have raised is very relevant. In fact, one incident happens in Shillong, and then you say, oh, women are killing their husbands, women are breaking up the law, or one suicide of Atul Subhash. This is where I would like to say, if I take a specific case of Atul Subhash, where was the problem? Problem was with the judiciary. Problem was that the case was registered in Jaunpur, and when both were staying in Bangalore. So the case should have been registered in Bangalore. So these are the problems which need to be looked into, not the law. Law is very clear. We all know it is women who face violence, women who get abused. So what are the issues that have to be handled? If a case goes on for 5 years, tarikh pe tarikh, then it is a problem. But men saying that women are misusing the law, no. Who is misusing the law? It is the police. If fake sections are put, it is the police that is putting the fake sections. It is corruption that is putting the fake things. So we have to tackle it there. The law is very clear, because dowry, even Pune recently, that girl who committed suicide, you had the Deputy CM flaunting the car keys, giving in a public function that here the girl's father has given a very expensive SUV. So this false narrative definitely will impact the carried by the media or certain sections of media. This is definitely impacting the judiciary. It is impacting. But yes, judges are not, may get impacted, but when they write their judgment, they will not be driven by that, because they will go into the merits of the case. But yes, Supreme Court came with that order saying, in one of the cases, it said 498A has become legal terrorism. Because what they are doing is, you are putting the dowry case not only on the husband, his mother, but there are cases that are being registered on sisters who are living in the US, who are not even in the city. It is being written on brothers-in-law whose names also they don't know. In fact, in one case recently, I got that 11 FIR squashed from Bombay High Court, from the Justice Gadkari's court. The divorce had happened, but the police of Navi Mumbai had registered a FIR on the husband, his mother, father, 4 sisters and their husbands, 11 people. And when we went to the court, in fact, I was appearing from the husband's side, and I said, Lordship, if the divorce has happened, where you say that you will not put a counter case, but it is the police. So the police officer was called, and the police had nothing to give a thing. They had taken money. They usually take money and make these FIRs. So I feel we need accountability of the police officers who are misusing the law. Because if you see, charge sheets are filed immediately, because they know that the other the side has money, and how much money they can knock off. So I would say the law is being misused, made use of by the police officers. So the narrative saying that women are misusing the law, no. A woman is only coming to say that I am being beaten up, or the dowry has been asked. Why are you putting FIRs in the name of women who are living in US and UK? So I think accountability and action on the police should be taken on the corrupt cops is required, rather than tweaking the law or weakening the law.
Yeah, thank you, Abhaji. I think others can ask questions now. Pooja,
Yes,
if you can come in.
Yes, I think Malika ma'am wants to ask. Ma'am, you can unmute yourself and speak.
Yes, Malika ji.
Hello, thanks. Yeah, thanks. I really enjoyed the session, as I expected to. You have done full justice to my curiosity and lots of information. But I missed what you were saying about the Supreme Court's order on conducting a survey on the internal committees in August. Could you please elaborate on that a little?
Yeah,
or maybe share that slide?
That is very important. The ICCs, the Internal Complaints Committees, it has said that when Vishaka happened and then the Me Too movement happened, there are still many organizations that have not set up ICCs. You know what the law says, where there are more than 50 women, an internal complaint committee should be set up. And if there are no ICCs because there are less women, then there should be a district complaint committee. That is the district complaint
committee. The local committee, and 10 employees, whether it be women or men.
ICC is separate. Then if the ICC is not set up, then there should be Section 6 of the Sexual Harassment at Workplace Act says that there should be a local committee. It is called LCC. If there is no ICC and a woman is facing sexual harassment at workplace, then she will go as per Section 6 of the Sexual Harassment at Workplace Act to the LCC, which is set up by the district collector, who is an IS officer. And this LCC will have not only the collector, somebody deputed by the collector. It will have, one member from the panchayat. It will have a chairperson nominated from eminent women in the field of social work. So when you go, it is your right to see to it that LCCs are made, and the chairperson will be an eminent woman in the field of social work, committed to the cause of women. One member to be nominated from amongst the women working in the block, taluka or tehsil or ward or municipality in the district. So, Section 7. Section 6 says there should be a local complaints committee. Section 7 says that the composition will be one eminent woman as chairperson, one member from the panchayat or the municipality, two members, of whom at least one should be nominated from an NGO or associations committed to the cause of women or persons familiar with the issues relating to sexual harassment. So, what will happen is, the advantage will be, and also it says, provided that at least one of the nominees should preferably have a background of law or legal knowledge. So when your ICC is weak, if it is under the owner, then if there is an LCC, that LCC will dispense justice, because I have the option to go to the LCC, and because LCC is constituted by the district collector, who is an IS officer, he would not be in any company politics or party politics. And so this will, and also it says that at least one nominee shall be a woman belonging to the scheduled caste or the scheduled tribe or OBC or minority community notified by the center. So now these LCCs are not there. When these ICCs had problem, I said, let us find out about the LCCs. But because, as you all know, women are always low priority. Rape will become a big news because it is between, you are running down a state government and it is a party politics or political war. But safety of women is low priority till the time media makes it hyper and they are getting brownie points. So Supreme Court recently said, Justice Nagaratna, that see to it that these district complaint committees are set up, which are called the LCCs, local complaint committee. And so if you are working at the ground level, go meet the district collector and say, can we have the composition of the LCC? And if you're not getting justice in your school committee, because colleges, we just had this girl in Odisha committing suicide because she went to the ICC and the ICC did not do anything. So then what issue we raised was, where was the LCC? Why did the LCC not come in? LCC definitely will be more neutral, because colleges, if they set up an ICC, they will have their own teachers who would be scared of the principal. And if it is a private college, then the teacher would be terminated if she takes action against a principal or she takes action against the trustee of that college. So it is in our interest that these LCCs, as given under the Act, are set up, and we go to them, we involve them, and we make them accountable. So this is what the recent order has said, that wherever LCCs are not there. So you quote Section 7. Quote Section 7. Section 6 is what says the LCC should be there, and the Constitution. So in fact, there is a notification that the appropriate government may notify a district magistrate or additional district magistrate or collector or deputy collector or district officer of every district to exercise powers and discharge functions under this Act. So, this is what. So let us go. Why should we stick to the college if it is not set up an ICC? You have the rights under the Act to say, go to the DM, to the subdivisional magistrate, and say that this notification provides. So now this order which is there, the last order, if we can take out, where the Supreme Court has said, I will share this presentation with you all, insist on it that the local complaint committees are authorized, empowered to give justice to women colleges students who are, 2 children committed suicide in Odisha. What was the collector of that district doing? Why was he not made aware of it? So I think till the time we become vocal, we know what the committee says. And I, in my PIL in the Supreme Court, which is before Justice Surikant, I have said this only, that if the ICC is incapable of dispensing justice, if the ICC, then the LCC should step in. And the LCC in cases where an ICC chairperson in the private sector has to take action against a boss, then the LCC should come in, because that will be more neutral to dispensing justice.
Right. Abhaji, there are other
What
people
is the
also
law?
waiting to ask you
Yeah.
questions.
And you said about a survey that the Supreme Court has asked. What is that? That was really interesting.
Just open that slide.
Yeah.
That is under that court. That is
Mhm.
under this order. I'll just give you the case law. So,
Yeah.
and I can send you the details because.
Yeah. It was the third or the fourth slide, I think.
No, last second before that.
Mhm.
This one. No. This one, Sabu Matthew George versus Union of India. This is the case. From the apex court in this case, it will be here. Here. Supreme Court pushes for POSH Act compliance. Justice B.V. Nagratna. This is in Aureliano Fernandez versus State of Goa. This is of 2025. So in this case, district-wise survey on constitution of ICCs to be done. And this was Justice Sanjay Karol, Justice Prashant Kumar Mishra. They were there initially, but this latest bench was of Justice Nagratna, and they have ordered that this survey should be completed within 6 weeks from 12/8/25, if not already done. So this is what is very important, that labor commissioners should be involved. If you have labor officers, go to them and see to it that they will. The Supreme Court has said that labor department is responsible to ensure compliance and take action where ICCs are not formed. So if there is an organization so you can quote this order of Supreme Court on the implementation, Aureliano Fernandez versus State of Goa. This is a 2025 case, and this was decided on 12th August 2025. So this is the recent, and I have really worked for 1 week for your presentation, because I wanted, you all are so focused, and I knew all activists would be there and journalists, that so the labor commissioner, the labor office has to see to it. So all the districts labor officers, please, you have now an avenue that you move to the labor office and say this does not have ICC. And under section 2OP and section 4, employer's duty to constitute ICC at every workplace. And 6 weeks means 12th August it happened. So 12th September, I think by 30th September, the time gets over. And if it is not done, even if you give it to me in my next hearing, I will see to it that it is communicated to the Supreme Court. Yes, sir. We can take the next question.
Yes, I believe. Yes, Pooja, please
Yes.
get the next question
There
through.
is one question in the chat box by Akshay. He says, thank you for the session, and I really appreciate the focus on laws like POSH, POSCO, DV Act, and PCP-NDT. And his question is, when we talk about gender-sensitive reporting, how are groups like female sex workers, MSM, or transgender persons being covered, since they often face privacy violation, identity exposure, and stigma in media? I wonder how that fits into the framework of responsible journalism.
Yeah, exactly. In fact, I did do it, but I thought because it was 2 hours, so I couldn't have exceeded. But I did do little work on it, and if you want, I can share it with you also. That Transgender Protection Act has come, Transgender Persons Protection of Rights Act 2019. That is the new act which has come. I didn't do it because it was and that was not the mandate, but still I was thinking that this act, Protection of Rights Act 2019, and it clearly, section 4, it talks of right to recognition of self-perceived identity. So whatever identity I want, that has to be protected, and you can get your magistrate. Section 5 of this act, it talks of that you can apply to magistrate for the certificate of identity, because what bigger problem you have is your identity crisis. But now that if your identity is protected by this act, I don't think you would be stigmatized at all. And you can also get a revised certificate for gender change. So, surgery, Section 7. So this Transgender Protection of Rights Act 2019, it in fact, Section 13 of that, it also provides for inclusive education, sports, recreation, leisure activities, then right to medical care facilities, right to change first name in birth certificate post gender surgery. So this, I would like everyone to go through this Protection of Rights Act 2019. And for the police, if the police are victimizing you, troubling you, then this act clearly says that it prohibits discrimination, unfair treatment. Section 3, it prohibits unfair treatment, discrimination, and it gives instructions to police that they cannot discriminate. And this act, it clearly talks of it, and it also says that unfair treatment, denial of education, employment, all that you can move these authorities. And there are obligations of rescue, protection, rehabilitation. And this act itself, I think,
Okay.
I think she's facing some technical issue and got dropped.
Okay. Please bear with us, everyone. She will. I will make her rejoin. Just bear with us. Abhaji, if you can hear us. Pooja, you want to call her?
I'm doing that.
Please rest assured that all your questions will be taken and we will answer each question. And so please bear with us. This is just something which is to do with the internet.
Yeah, she's rejoining. Re-went off
Yeah,
actually.
yeah. All right. I think Mona Tai has said something in the chat box. I couldn't see it. It just flashed on the screen and went off. I couldn't read it.
It says, is it possible to list my questions to you via an email and wait for the response, since it is impossible for every participant to ask questions?
No, tell her to be around for means that after we'll come to her question immediately now. I mean after Ritu's there'll be I think Ritu's question and then this one.
Yeah, then Mona ma'am.
Yeah, just convey this to Monata, this is I don't know whether she can hear me, but
Yeah, ma'am. Mona ma'am, we'll take your question after Ritu ma'am's question. We just request you to stay back for a minute. I have a long list of questions. I can hear you. Okay.
okay. No, I mean at least the main question that you have, you can ask yourself, and then the other questions you can obviously then I'm sure Abhaji will share her contact details or something like that. Then you can mail it to her, or you can do it via us. So actually, I am so technically challenged myself that I am never sure of whether the audio and video is going across.
Okay, via you would be great, ma'am is saying. Mona ji.
Okay. Yeah, I mean that's fine. At least if there is a question, a specific main question that she has, she can ask that directly, and then we can take other questions via mail.
Yeah.
Abha ji is joined. I think
No,
I can see
no,
one
no.
sign in with her name.
Yeah, that's Tisha from her team who was sharing the screen actually.
Oh, okay. Did you speak to them?
Yes, I did.
Is the Zoom timed out or what?
No, not the Zoom. I think that's the laptop's battery went off.
Oh, okay.
Okay, Mona ji has shared her question. Please state the section law that says compliant must be given the complainant must be given their FIR in a language they understand.
Okay. Maybe Abhaji could join via phone or something. Yeah.
Yes, she's back.
Yes. Can you hear? Yeah, you'll have to unmute yourself. Unmute.
So sorry, I was so involved that I didn't see that my battery had.
No, that's all right. There were a couple of questions. So Ritu and Mona Ambigaonkar, the activist, is here with us, and she also has a couple of questions. So yes,
Ritu, yes.
Rituji, please go
Please just
ahead.
unmute yourself and go ahead.
Unmute yourself, Rituji.
Yeah.
Yes.
Am I audible?
Yeah,
Yes,
yeah.
yes, you are absolutely.
Yeah.
Sorry for the inconvenience. Sorry for making you all wait.
Abhaji, thank you for the session. I think it was very thought-provoking and also a very well-researched presentation. I have a very specific question for you. I wanted to, and also in a way, seek guidance from you as a journalist. So I wanted to understand your views on the way media puts the graphic description of rape. Because we obviously know we can't diverge a lot of details, right? So the next thing as a journalist we would do to create impact is to have the details about the atrocities involved in the crime, which in a way sways public opinion, and then impact unfortunately becomes a byproduct. And I'll give you a specific example. We saw that in the case of Hathras, right? In the Hathras rape case, firstly the local courts had acquitted the three accused, and one was convicted, and then the Allahabad High Court took the suo motu cognizance, and then the CBI investigation was done, and all four accused were then convicted. So in that way, the media, obviously a part of media sensationalized it, but there was also the part of local media that did their job of reporting the facts, which found that the UP police was at fault here, and did not do the medical examination as they were supposed to do if the victim is claiming that she was sexually molested. So I wanted to understand in this case, how do we tackle, and at what point we should understand our boundaries as journalists?
I remember Hathras was a very sensitive issue, and when even we were researching, because I was also on quite a few channels when we were talking about it, what information we found was this, that they did not have the kit. They did not have the kit to do medical for rape. So that kit was lacking, so they delayed it and they did not do it. So definitely that is where the role of media actually became very important, that why was the medical not done of the rape, why the hospital refused, or so it is definitely a very thin line, that certain issues of the police, if the media doesn't cover, doesn't write, nothing is going to happen, because they would try to that is the mindset of every police station, that they don't want any crime to be registered, because it spoils their progress report, yeah, their daily report. So I think there, for the media, it becomes very important. The only thing is, which everybody again and again, is cover the incident. but don't leak the identity. The family, if they get to know, people reach their homes. So if there are other people there, then somebody, some relative, then the other defense, the other side will try to bribe them, pay them money. There was this case, like there's so many times. So what is important is the identity has to be protected. You have to speak about it, because so many times, I think if the IPS officer's video was not viral, Ajit Pawar as Deputy CM would have crushed her, suspended her, transferred her. So the importance of media is very important in a democracy or anywhere, role of media. But in rape cases, going to the the tiniest of the thing which really makes you puke. I think that just because for TRP or to get one man above, that is where it should stop. And I think it cannot stop just by the journalist doing it, because then you will lose out on your TRP, and then your bosses will say, no, you are not effective. Then it affects that way also. I feel this is where the courts need to come in. The courts need to come in, that these issues of accountability should be with the owner. That why did you cover like this? So accountability should be, but there is a thin line. You have to cover, but the identity part we are really concerned, because the identity part and those private things, which it becomes difficult for people to sit in the house with tiny children watching, like it becomes a pornography rather than a news, because if you're going to go into this, so that regulations are required. And I know, but I would still say you journalists do a wonderful job, because if these things are not got out, justice doesn't come. Because as we said, the police doesn't want to register the case, then the other side will come and bribe the judiciary or the registry, the cases will not come up for hearing. So media's role cannot be denied. Only thing is the identity part. I feel if somehow, rather than going in with a camera in front of the mother, asking the mother, aapki ladki karti thi, kya karti thi, kiske paas jati thi, that becomes a little, I think, it revolts our conscience. In fact, I was going through a case of NDTV, which we didn't put it in the presentation. It is there in the presentation, where NDTV covered it, that in the Nanda case, the BMW hit and run case, where the councils tried to pay money. Pay money to the witnesses to move out, and the Supreme Court came heavily, and it came heavily, and it absolved NDTV. It said no, they ran it, but that was in the interest of justice. But the lawyer, one lawyer they put him behind bars, and one lawyer they absorbed. Like this case, yeah. This case, if you see, R.K. Anand versus registrar, this was BMW, was run by Sanjeev Nanda, and the trial was for a year. NDTV conducted a sting operation telecasting footage which allegedly showed R.K. Anand, defense lawyer for Sanjeev Nanda, and Ayub Khan trying to influence and negotiate with witness Kulkarni. The sting material included meeting and voice tape. So like this was there. So if you see, what did the Supreme Court say? The Delhi High Court took suo motu cognizance of the expose, found that both the advocates, very rare it would be that the judiciary went against its own lawyers, and it said, you are trying to influence a prosecution witness. And the High Court punishment, it debarred the both from practicing in Delhi High Court or subordinate court for 4 months. They gave a fine, and they recommended that R.K. Anand be stripped of his designation as senior advocate. And now you come to the NDTV. Supreme Court on 29 July 2009, the Supreme Court upheld the conviction of R.K. Anand for contempt of court. It cleared UU Khan the actual contempt. And the Supreme Court said that NDTV sting operation to be in public interest, not a trial by media. It clearly said, in fact, how I missed it, good you asked this question. We have held that the sting program telecast by NDTV in no way interfered with or obstructed the due course of any judicial proceeding. Rather, it was intended to prevent the attempt to interfere with or obstruct the due course of law in the BMW trial. We have also held that the sting program telecast by NDTV served an important public cause. So I will not praise NDTV, but it said there, and then of course,
I'm actually feeling very nice that you're raising this, Abhaji, because Poonam Agarwal, who did that sting operation was my fellow Shivning scholar when
See.
we were both on the Shivning scholarship together at Cardiff University. And she's a very dear
Uh-huh.
friend, and she
Oh,
continues
how
to do the
nice.
excellent journalism
Please
even
tell her
now.
that I don't know her, but because merit this.
Yes.
So that it very clearly says that the matter of coverage of news, impartiality and objectivity in reporting, reach to the audience and capacity to influence public opinion are actually better than many foreign TV channels. What a compliment you all got. But what I'm trying to say is that sting operation was upheld by the Supreme Court. So it's you have to just be in rape cases, identity and that little decencies should be maintained. Beyond that, though, it is good, it is in public interest that these cases from far-flung places, they get reported and the FIRs are registered, and these politicians and rich people, they go behind bars. You all play a very important role.
Okay. Pooja, please ask the next question.
Yes, there are a couple of questions from Mona Ambikar ji. The first is, please state the section or law that says complainant must be given their FIR in a language they understand.
Okay, I'll give you that is a CRPC. That is that was in the CRPC, which says, I think 122. Just get me the bare act. You can just see where it says it should be given, because Adit, can you tell me the section where the FIR should be given in the language you know? That was in CRPC. So what is that?
I just said BNS is just it.
But CRPC, what was CRPC? 120?
154.
154 of the CRPC. And it should be in your own language. It was in CRPC, it was 154, but I will just tell you the section, because that is very important, which I... yeah, see. Yeah. 173 of the BNS. While the overall process is similar, the BNS introduced new provisions such as EFIR, zero FIRs, and the opinion for a preliminary inquiry in some cases which are not. So now 173 of the BNS, 173 you will quote, earlier it was 154 of the CRPC, but now BNS it's 173, which says that EFIR, zero FIRs and all this, you can get this and in your regional language. Just take off 170.
Ask the next question.
Yeah, the next is, why is DV a civil case and not a criminal case, even if it clearly says domestic violence?
Domestic violence cases.
See, there you had 498A. Even for getting hurt, there are enough sections. If you are getting beaten, the IPC is there. But you needed a civil law also, because criminally you are going parallelly. If you are beaten up in the house, you can file under the causing hurt section. Because of the BNS, all the sections have changed, but I've given those sections somewhere. So you have under the IPC, nothing stops you from now doing complaint using the sections of BNS. So DV is a civil act where it is for the reliefs which you want, because law is not only criminal, law is civil also, civil criminal. So civil procedures where without putting the person behind bars. See, because the logic is that if he is behind bars, how does he pay you the money? How does he give you interim maintenance? So DV is a civil act where civil remedies are given. Just one push or hit. If it is a criminal thing, you go for a police FIR. But in husband-wife, so many issues, it is not criminal all the time. There may be a peaceful settlement where you are not getting along, you want to move out. So DV is a civil law, which criminal already there are enough sections. So DV, the logic was that there should be something which is not criminal in the civil, in a civic manner. If you want to split up, you want to divide, you want to move out. So you want to stay together also in the same house. So that is why it was a civil act.
Abha, it can happen simultaneously. The DV, the civil one and the criminal one can happen.
It goes on together. You do your dowry,
okay.
Your DV is separate. You will, meanwhile, you will file DV. You will go for your criminal. The law says that criminal and civil go parallelly. They go together.
Okay, fine.
So nothing stops you from doing your criminal case. But this is a civil law, under which you get residence.
There are several questions that our friend actor activist Mona Ambegawkar has raised. we will send them to you by
Yeah, I
email,
think that is
and
better. If you can send me the questions.
send you the questions by email so that you'll be able to respond to them. She's also asked for that to be done.
Okay.
And I think if there are any other questions in the chat or anybody else wants to ask their questions here.
No other questions in the chat box.
I think that's good enough. And
Okay. So
anything else?
we want to thank you, Abhaji, for making time on a weekend and coming and talking to us and presenting everything so in such an accessible way. Very importantly, this is very important. Both as a judge, whenever I've come to you or whenever I've spoken to you, I realize that unlike most other legal eagles who one speaks to, you make as far as possible whatever is being said. You are you make it accessible and understandable to every one of us. So, and in a very conversational manner. So this is I felt that was there in today's presentation also. As far as possible, you spoke in a language where all of us can understand and every little aspect of the technical things that you were mentioning. Thank you so much on behalf of Population First and all the attendees. I would like to thank you for making time to do this. Thank you, Abhaji.
Thank you, Population First, for having this. And I think you all are doing excellent work, and gender sensitivity is something which is on the increase. And I think Population First has a very important role in that. And UNFPA also, which is your partner. I think both of you are together, each other's strength. And I'm glad that you will be the strength of the women in this country. Thank you so much.
Yes, Sumedh.
Thank you, ma'am. Thank you so much for giving you valuable time for this.
Thank you. Thank you.
Thanks.
And we will, if anybody here wants to ask any more questions, then please feel free to mail us, and we will convey the same to Abhaji and try to get you responses to each of your questions. Thank you so much to every one of you for joining.
Feel free to write to me, email me. You have my email, so just send it to me. And of course, I'll be happy because ultimately, being aware, knowing your rights is something that will really get you justice. So, for sure.
All right. Thank you so much, Abhaji, once again.
Thank you.
Please, my regards to YP sir also. Yeah.
Sure.
Srimati is asking what is your email, ma'am?
You can send it at Abha Singh Law Offices at gmail.com. ABHASINGH, Abha Singh Law Offices at gmail.com. And
okay.
Otherwise,
I think it's on your screen. Everybody.
Email handles are Abha Singh Lawyer. I run an NGO called Ransama Foundation, where we are, if you follow that, anything which is happening, we are trying to give the laws and the rules that how you can get it. So Ransama Foundation has been working. We are trying to dispense these things. So whatever I put up, I'll put it up there also. So you can just check out Abha Singh Lawyer on the Insta also.
Yes, and it's come up now on your screens, everybody. If you see the emails are there, so you can obviously directly write to Abhaji, or if you want, we can also be the conduit for conveying this to her. So please feel free to, and please follow her on her social media handles. There is a lot to glean from them as well. Thank you so much, everybody.
Abha Singh Lawyer. You can just check me on Insta and Twitter. It's Abha Singh Lawyer.
Thank you, Abhaji.
Okay, bye-bye. Thank you.
Bye-bye.
Bye, ma'am.